Hi, this is Brett Sykes, the Right Brain Business Attorney, and today I am talking about mediation, which is a type of alternative dispute resolution. And disputes are historically in the United States fought in court. Litigation. Litigation is time-consuming, it's expensive, it's what even the lawyers describe as a lose-lose-lose process. The clients often say the only people who come out of this winning are the lawyers, but I can tell you I didn't do a ton of litigation, but when I'm involved in it, my client's never very happy. No one's ever winning. They're really not happy, even if I do an amazing job. Just with the whole process, I don't feel like I win either. So it's a rough process. Part of why I don't really like to be involved. The dispute work I do is headed off before litigation almost entirely. So litigation, probably, I don't know if I've got my dates here, but maybe 40 years ago, something like that, alternative dispute resolution mechanisms started to pop up. So the two big ones are mediation, and arbitration. So arbitration is kind of like litigation, and there's different systems that you opt into in your contract up front. You agree, if we have a dispute, we're not going to fight this out in court. We're going to go arbitrate it. And we're going to choose the American Association of Arbitration, or JAMS, which I think stands for Justice Through Arbitration Mediation Services, or something like that, Judicial Arbitration Mediation Services. JAMS, there's other ones internationally, the International Chamber of Commerce. They have these systems where they bring private parties in, and they have people who serve as arbitrators. They could be ex-judges or lawyers, and you pay the arbitrator by the day. You can have one arbitrator or three, but it ends up being a lot like arbitration. If you choose streamlined or simple rules, depends on the system you're in, then they could be a little bit quicker, but generally speaking, it's time consuming. Mediation is what I want to talk about today. And aside from certain circumstances, certain types of companies and contexts, you should include this in every business contract. So I'll get to the times when you might not, but almost universally you should use this. And the lawyers, for some reason, most lawyers actually don't love to use mediation. And I've got some theories as to why that is, but let me explain first what mediation is. So unlike arbitration and litigation, where at the end you get a result, and you usually pay a lot of money and expend a lot of effort and time to get that result, you get a result. An arbitrator or a judge says, you're right, you're wrong, here's what happens. Mediation isn't like that. Mediation is much quicker, number one. Most mediations take place over a half a day or a full day. It's much less expensive. You can expect to pay a mediator something like $750 to $1,250 per side. And you'll go in, each party, usually represented by attorneys, but don't have to be, and you just tell the mediator your side of the story, and the mediator tries to get you both to come up with an agreement. You build it into a contract up front. It's required, but fundamentally to make it work, both parties have to attend a mediation in good faith. If one shows up with no intent whatsoever to listen to the other side, you're not going to be able to get a lot accomplished. And I think that's probably why a lot of attorneys don't like it. They've seen it not work often. I've seen it not work often. I've seen it work, though. And for that amount of money, something you could do very quickly to try and get the parties across the table and just come to a resolution. And a good mediator is going to be in there breaking the parties up and working them a little bit, telling you you're strong here, but you're really weak here. And this is their position. Do you see that? And try and get the parties to come back together and come up with a resolution. The mediator is not going to say, here's the resolution. They're just going to try and make the parties reach an agreement. And if they do, typically the mediator will put together a settlement agreement. So again, for that amount of time and effort, I think it's definitely worth, and almost universally worth, the effort to build it into your contract up front. I was general counsel of a public company, and I would see oftentimes we had we had our share of litigation. It was a big company. It was a big company, and we were doing business across the globe and a couple thousand employees, and stuff comes up. And I would often see the business people, this relationship. I mean, whether we were selling something, we were buying something, whatever, the business people were on the front lines involved, and this had started off as a relationship, and it was positive, with the vendor, with the customer, and somewhere along the line, it got off track. And it gets so off track that the business people don't want to even talk. They're yelling at each other. They're saying, we'll get our lawyers involved. And then they throw it over to us, the lawyers, and say, go get them. Well, what go get them means is years of money and effort and expense and time, and it's painful and emotional just to bring the business people back to the table to talk about a resolution at a point in time when, as they'd say down in Texas, they were rode hard and hung up wet. It's basically just like, just brutal, and okay, now let's go figure it out. So to me, it's like, let's take a day or two and go figure it out on the front side. Now, emotion sometimes doesn't allow that to happen. Sometimes that resolution can only come after a pretty painful process and after things have really cooled emotionally. But mediation, I think building it in makes some sense to at least try to get the business people back to the table to talk about where things went wrong and to see each other's point of view. If you're the smaller player, right, so if your counterparty, your customer, is much, much bigger than you, you should absolutely push for mediation because you will be outmatched in arbitration and litigation, and they're likely to know that to the point where they can push you around if it gets to that. And now some companies who have that sort of muscle don't want to agree to mediation up front just because of this reason. Most are open to it though, and then if your attorney pushes for it, it's real hard for the other side to say no. When I say, really? If something goes wrong, you won't agree to get together for a day and just talk about what went wrong? That just seems why would we want to not do that? It's hard for the other side to say no. So a lot of times you'll have success getting it built into your contract up front, and you need to do that because if you don't build it in up front, you might end up in a situation later on where both sides are not talking to each other, can't come up with a resolution. When I say left, you say right. It's like, now is the time to bake that into a contract. The only time you would consider not having mediation is when you're the really well-heeled company with a lot of muscle and you just, as a matter of course, refuse to do that. You want to retain your ability to push the other side around. And I understand that. And I've got clients who that's their position. So that's my position, right? I work for the client. Personally, in my business affairs, in my engagement letter with clients, I'm happy to mediate, happy to sit down and understand your side of the story, right? Like that's really keeping with who I am and how I want to be in the world. But that's a philosophical thing, and it's their entitlement, and it's fine, and everything's negotiable in a contract. So outside of that context, if you take the view I do, it doesn't matter if you're the big party, if you're the party with more resources or less, or you're a party with plenty of resources, but you always think, hey, to spend a day and listen to the other party's side is fair. We hate litigation. You should absolutely build that into the contract up front. When your attorney says, nah, you don't want to mediate, say, yeah, I do, right? It may not work, right? I don't know the statistics on it, but I've got to think it doesn't work more often than it does. But that doesn't mean in the overall context of dispute and what's ahead, if you can't figure out things quickly and easily through mediation or some other informal meeting, if you go to arbitration and litigation, they're so time-consuming, expensive, and brutal and emotionally painful that it's worth giving this a shot, even if it doesn't work out. If you have any questions about mediation, if you're categorically opposed to it, if you want to understand a little bit more about how it works in a contract, call me, drop a comment. By all means, drop a comment about other things, other questions you have about any of this dispute resolution related things, arbitration, litigation, and I'd be happy to give you some feedback or to do a video based on what I hear. Thanks.